I have that. I think I probably, let me see here.
I do have their proposed orders, but I believe there's also another conflict case on. I may have to reach out to court administration because I didn't get orders on that one yet.
Was one you heard? Okay. So yeah, so if you want to go ahead and handle that one.
Okay, I'll go ahead and take this if Ms. Bliss and Ms. Petrie are on. The Mathers v. Seal.
Your Honor, I was going to be asking for at least a week set over. I just received these orders late yesterday. I've hardly had the opportunity to review them. If Your Honor wants to proceed today, I can quickly go through and figure out if there's any objections. But I think for efficiency purposes, it makes more sense for me to review, maybe get some objections to Ms. Petrie, see if we can't resolve, and if we can, get those to Your Honor for a ruling.
Okay. I have no objection to a 1 week set over.
Okay, that's fine with me. I can step on if we just set this to next Tuesday. Obviously take the objections into account, but I just wanted to make it clear. I went back and looked at my ruling and I did find adequate cause. So I'm not reserving on that. The proposed order says I'm reserving on that.
I'm sorry about that. I think I got that confused with another case where Judge Gonzalez in Clark County adequate cause. That was my error.
No problem. So I just think it just needs to be wordsmith saying I found adequate cause, but I declined to change the parenting plan pending a GAL report.
I think
so with that, I think Ms. Petrie and I could probably craft some language, and then I think, at least from my brief review, there's probably very minor issues. Okay. I'm hopeful that Ms. Petrie and I, we typically work pretty well together, that we'll be able to resolve that, but no less, if we could just have you pop on first thing next week, just in case there's any issues, and obviously if we reach a resolution in the meantime, we'll go ahead and notify admin so that you don't have to appear.
Okay, sounds great. I appreciate it. We'll set you on next week at 1 o'clock.
Christine Dow
Thank you.
on?
Yes, Your Honor, I'm here.
All right, good afternoon. This is on for pretrial today. Looks like there any issues that need to be addressed by the court at this time?
Well, Your Honor, if I may, since we're the ones that set this trial, this is the first pretrial management hearing I've had in Cowlitz County, and since the local pretrial procedure rule was repealed, I am not really sure how you want to proceed with this. I'm assuming that this is for informing the court where the parties stand in preparation for trial and to receive any directions that the court feels are appropriate here. My client has had ongoing medical issues, but we are largely ready to go. I don't know if you want me to go through the issues that we are still going to be looking at for trial. They were largely addressed in the CR2A, and I filed a motion in limine yesterday. I sent out a set of requests for admission to Ms. Palmer back in April, and I did not receive any response to those until she responded to a request for a 26I conference. Essentially, her response was in line with all of her other responses that no, she wasn't going to do it. So if the court grants our motion in limine to deem the facts admitted that were contained in the request for admission and enforces the CR2A agreement, the only issues that are going to be left are for things that have arisen really since the CR2A was executed. And mostly they have to do with offsets against each party's distribution.
Okay, well, this today is on just simply to see if there are issues that need to be addressed prior to the readiness hearing. So it's not on for an actual motion.
Okay, the only thing that I can see that would have to be addressed would be that motion in limine, and I set it for hearing on the 20th, which is when our readiness hearing is scheduled for. I was hoping that Ms. Palmer was going to
set that prior to that time because we don't do motions on readiness hearings.
Okay, no, I set it for the docket.
Okay, as long as it's set for the docket, we can deal with that on the 20th. It looks like, and
yes.
Goes. Well, the problem is going to be is you're going to have a readiness hearing prior to that.
Yeah, I realized that late yesterday afternoon when I was looking at the times for these things. If for some reason the court does not grant that motion, I'm still ready to address those issues at trial, and they are focused primarily on the issues that arose after the CR2A was executed. And they mostly have to do with missing personal property.
Okay. So we'll leave it on for the 20th and for readiness. And maybe talk with Ms. Dow at all on any of these issues?
Have I talked to her? No, I just got an email from her today about the admission stuff, but I don't remember, I don't know. I'm at the courthouse now. I need to know what that form is that I have to put on the paperwork. Christine, the form that I need to fill out on my side was to put on file for the case you told me today on the email. What's the form's called? What's the form numbers?
What I served to you by email and followed up with service by the U.S. Postal Service was a motion to have all of the facts that were addressed in the request for admissions deemed admitted prior to trial. Once again, you ignored what I sent you, and the only response that I got from you was...
So I'm just asking you, you asked me to fill out a form, and I have to the 16th to file the paperwork. What is that form that I'm supposed to get from the courthouse today?
No, I did not ask you to do that.
All right. So at this point, I don't have any motions pending. I'm just trying to determine what issues are left before this is ready for trial. If it's ready for trial as it sits, we can leave it on for readiness. And then go from there. Ma'am, if you, I can't give you legal advice and Ms. Dow doesn't represent you, you probably want to get some legal advice on this case. I don't know anything about your case other than it's on to see if you're ready for trial at this point.
I don't have an attorney, so.
I understand that. So
And
what I would...
all the legal things that you guys keep sending me, and none of them would help me.
Okay. Have you checked with the, if you show up here on a Monday between 12 and 2, there's some...
already too, yeah.
I'm sorry?
I went through them already.
Okay. And were they able to help you? Okay. You're set for trial at this point on the week of August 26th. You'd come back 2 weeks from today for 11:30. You'd actually do that via Zoom. And you can come here and use the Zoom booth if you don't have a good access to that, to set the actual day your trial will be heard.
On the 20th of August, right?
20th of August, 2 weeks from today. It's at 11:30.
Okay.
And then we can go from there. You've also apparently got a matter set on this docket on the 20th as well, which you can appear in person.
I'll show you when I gave my finger off.
Okay.
The 20th?
On the 20th. You actually have two hearings on the 20th, one at 11:30, one at 1 o'clock.
What's it at 11:30?
That's the readiness hearing to get your trial date for the following week.
And 1 o'clock?
And 1 o'clock for whatever motion has been filed for that date. Well, if that was just filed.
That was just filed yesterday, Your Honor.
Okay, that's probably not timely for the 20th, but.
I also filed an ex parte motion for an order to shorten time. Your Honor, I'm looking for a little bit of direction here if you feel it's appropriate. I don't want to delay this any further. This has been delayed at least 2 years beyond what this should have been completed. However, given that Ms. Palmer does not have an attorney and she appears to not understand what she has been receiving or what she's been dealing with, if in your opinion we should set out the readiness hearing and maybe reschedule the trial, I'm willing to do that, but not for very much longer.
Well, I don't see any reason to reschedule anything at this point. I mean, we can deal with the motions and eliminate day of trial if we need to.
Okay.
Do I have to have an attorney, Your Honor?
You do not have to have an attorney, ma'am. You certainly have a right to have an attorney if you choose to hire one, or if somebody's willing to represent you. Okay. And I can't appoint you counsel at this point. I don't have any basis on which to do that. Okay. So we'll be back in 2 weeks on the 20th at 11:30. You need to make sure you can Zoom in. If you don't have that access at home, come here. We have Zoom available to get your actual trial date for that following week.
At 11:30, and then the 1 o'clock is for the motion for the admission, whatever.
1 o'clock is a motion in limine. You probably should look through those and see if you have anything you'd like to file for the court to consider.
Yeah, so I have the papers and everything, but I need to know, how do I file it with the court? What forms do I need to get from the?
You just would file something that responds to the requests that are being made.
Is there not?
There's no specific form you have to file, just something in writing that responds to what their requests are.
So is it a generic form? I have to get something from the Superior Courthouse, I thought, to file.
There's no required form. There's just, you need to file something that I haven't read their motion. I don't know what all they're asking. So you need to read that. And if you have a position you'd like to take on anything they're asking, put that in writing and file it with the clerk.
Okay, got it.
And if it's not in a proper format, they've got a cover sheet they can give you to put on top so it'll get filed.
Okay,
Okay?
that's great. Thank you.
You're welcome. So leave it on the 20th at 11:30 and at 1.
Thank
Yeah.
you, Your Honor.
Thank you.
Okay.
Oh, by the way, is my husband gonna be present or no? Does he have to come at all to any of these things?
I don't know if he's going to be present or not for the next 2 hearings. He'll be present for the trial, I assume.
The plan is that he will be present for the trial. Yes, Your Honor. His medical issues are not severe enough to prevent that.
Okay. All right. So we'll be back in 2 weeks.
Is that better?
Thank you, Your Honor.
My understanding is that the parties have hopefully agreed to set this matter out a way as my client has requested it go at least a month. So my suggestion is we look somewhere in late September for a date to have the hearing.
Is that your understanding, ma'am?
Not exactly, but I mean, it is what it is. I don't know how long out we need to go, but I do have a few questions though before we're done.
Okay. I can't give you legal advice, but I can try and answer your question.
No, I just wanted to find out. So I know on the first court date I wasn't present, but the paperwork that I was served had said that court was at 1 o'clock like today, and I showed up there and I guess it wasn't. It was at I think 9 o'clock. And then I'm wanting to find out on service. So this is how I was served. It was taped to my house. I was not served these papers directly. They were taped onto my house. Is that how I get served? Is that a proper way?
Well, if you've received them at this point, then that would, and I don't know when those were taped, that wouldn't necessarily likely be sufficient for service for an original service. But if you received the notice, if you have the notice, then we can move forward. We're setting it out a ways. Part of the issue is to make sure you have enough time to respond to the paperwork. So if you've got the paperwork, at this point, we just simply need to set a hearing. If you had a question about the legality of that form of service or anything, you should get some legal advice. And we have some lawyers who are here from 12 until 2 o'clock, pretty much every Monday at the courthouse. So if you swing by, they can give you some advice.
Okay.
There's a charge for that. But at this point, from a process standpoint, it sounds like we just need to set another date out about a month or so. Do you want to go?
That's fine by me.
You want to try the 10th of September? That's a little over a month.
Let me check my schedule real quick.
Yeah, that day, Judge, on the docket, I think it will be done by then, but it might be one I have to physically appear for. We do maybe a week after that to the 17th.
The 17th?
Yeah.
Does that work for you, ma'am?
What time?
It'd be at 1 o'clock. Be just like this, and it's a Zoom hearing or in person if you choose.
Okay, that'll work. And what so is this just to go over the paperwork, or is this actual
It'd be
for
a hearing.
trial?
It'd be a hearing where I would review whatever was
Okay.
filed that you got, and then whatever you filed in response to that. And I would make some decisions if you and your husband, through Mr. Zandy, haven't come to some agreements ahead of time.
Okay.
So, and I'd urge you to reach out to Mr. Zandy's office. A lot of times these things can be resolved outside of court. That tends to be a useful way to proceed if the parties aren't that far apart. If not, then you come back to court on the 17th and I'll hear each side, hear your arguments, and I'll make a decision for you.
Okay,
And as far as that confusion on the date, I think what happened was that the initial notice was erroneously set for a different time. And so what ultimately happened is we set it over because we were aware that you were given the wrong time to show up.
okay. So if anything changes on this other date, will somebody notify me?
There will be no changes. It'll be at 1 o'clock.
Okay,
It may be a
Okay.
different judge, but it'll likely not. So
okay,
1 o'clock, okay?
okay.
All right. So if you're going to file something, make sure you file a copy to Mr. Zandy's office and to the court.
Okay.
All right. Ms. Bliss, I saw you on here.
Yes, Judge, I'm present.
So, Mr. Zandy, you said this was quick. I don't know if you.
It is. This is the case that the court has a little bit of communication with attorneys on this afternoon, or I guess earlier this morning. I was able to contact my client due to the timing of everything. We did get the response of meetings finally from Mr. Sane yesterday at about 2:30 or 2:45. My concern is this is what was filed back in April. It was sent over to June. At that time, husband finally reached out, said, "Hey, I'm looking to get attorneys involved and representation." Asked we set it out some ways. We did that. That was the July 9th hearing. Got the notice of appearance from Ms. Bliss prior to that. She had communicated that she was asking for additional time. This would be now the second or third set over at the husband's request. Go to court and largely opposed to that. Judge Scudder at the time did issue an award of attorney's fees for $750 paid by, I believe it was July 16th. That date came and gone. We have got time for Mr. Sane. I don't need to get served again. And I certainly do not blame Ms. Bliss whatsoever. I think it's pretty clear to see what's going on here. But we get the very late pleadings yesterday at 2:40. I was able to communicate with my client after communication with the court today about that 45-minute window that we had. She has a response. She wants to make that response, but like me, she's frustrated by the fact that now it's been 4 months and we've been set over and set over and set over yet again because Mr. Sane essentially refuses to play ball. And that comes at time, that comes at expense. Certainly comes with frustration, as I've said. So I'm not sure where we go from here. If the court does want to set this over 2 weeks, I certainly understand. I'm fine with that. But we would ask for, again, more fees, as this is now by my count about the third time we've been set to go to court. It's the third time I prepped the case, only to get a stack of information at the 11th hour yesterday, the day before the hearing. So we are asking, in addition to the $750 that's already been ordered, asking for an additional $1,000 if the court is going to set it over today. If you want to proceed with argument, I'm certainly prepared to do that as well. But my client does have some information based largely on what she received from her husband yesterday that she would like to provide by way of counseling records for the kids, criminal history pertaining to her husband, and a lot of the allegations that were raised initially by us and certainly in response to what we received very late yesterday.
Ms. Bliss, I understand you're going to be getting out of this case in less than 2 weeks.
That is correct, Your Honor.
All right. So, well, my thought would be, there's only been one court appearance since he was actually served. Would have been the appearance on the July 9th, correct?
That might be accurate. I'm going back to that June 4th in which he did contact our office and said, "Hey, can we have this set over?" Again, that was, I think it's short time before that hearing actually occurred. We agreed to do that. And here we are now, 2 months later.
Well, here's what I'm going to see. How much time do you think you could have a response filed in the next few days on your client's behalf? If we set it over a week?
Yeah, I can do that.
And Ms. Bliss, I understand you're getting out. Can you deal with a short notice response for next week?
Absolutely, Judge, that's fine.
Okay. I'm inclined to reserve on fees, set it over 1 week and the reason I do that, there's a lot of stuff here. I would like to hear your client's side of that. I went through and I didn't review all the documents. I just kind of glanced to see what we had here. And there's obviously, there's some financial questions that I have, and there's also a lot of other stuff being raised. So let's put it over 1 week. I'll address the fee issue next week and then we'll give you a decision, and Ms. Bliss will still be involved in the case next week.
And Ms. Bliss, give me a couple days on that. I'll try to get you something. Is Friday too close? If we file on Friday, get you a bench copy Friday afternoon.
It's fine with me. Yeah.
That'll work. Okay.
That's fine with me. Thank you.
All right, so over 1 week, and that will be, for the record, over to the 13th at 1 o'clock.
I believe I saw Ms. Wade present on behalf of Ms. Purcell. I see Mr. Young there, and I see you are muted. I just want to make sure, sir, can you hear me?
Yes, I can hear you.
Okay, great. Thank you.
And for the court's information, I represent Teresa Purcell, and Ms. Purcell is present in my office with me today.
Okay, great. So Ms. Powers, I think I have this on for motion for temporary orders. So I'll let you go first and tell me what you are asking of the court today.
Thank you. We have filed our motion for temporary orders, but as a preliminary matter, part of our motion includes a motion that the court appoint an attorney for Mr. Young. We have a protection order case also pending, and Mr. Young is currently up in treatment on a 180-day hold. And so it seems more appropriate that the court appoint an attorney before we address the rest of our motion.
Okay. Thank you. And I do recall, and will you remind me on the protection order case, did Office of Public Defense take that on? Is that your recollection?
They did. Mr. Angelico is representing Mr. Young in the protection order. It's my understanding that OPD is not willing to take an appointment in a family law matter, but I was hoping that the court could appoint someone else.
Yeah. And I'll just say I did review the family law matter. I know there will be requests for restraining orders and that sort of thing in this case. So I do think it's appropriate. Mr. Young, I would like to appoint you an attorney at no cost to you. Are you in agreement with that?
Yes, I would like to be represented by an attorney.
Sorry, repeat yourself.
Yes, I would like to be represented by an attorney.
Okay. I think given the circumstances and the particularly the ITA hold at this point, it is appropriate to appoint counsel. I will say, Ms. Powers, as you know, it is taking a little bit of time to find attorneys to take these cases on. I would guess no sooner than 3 weeks in order to find someone, and hopefully the next week, and then get them up to speed on the case. Would that be acceptable to you?
Yeah, that's fine. I know the protection order matter was set over to the 12th, kind of to trail this case. Mr. Angelico is not present, so I don't think it would be appropriate to set it over further, but if we could set this over to August 27th.
Okay. So Mr. Young, I'm going to sign an order appointing you an attorney. I will get that order to you once I know that attorney's name, and they will also contact you. We are going to set your next appearance on this family law docket for Tuesday, August 27th. Actually, I'm going to back up. If I need to step on, I'm going to have to go one Tuesday out because right now I have a trial that entire week. So I probably wouldn't be able to step on. Could we do September 3rd at 1 o'clock?
That's fine with me, Your Honor.
Okay. Mr. Young, right now, your next court date will be September 3rd at 1 o'clock. Do you have any questions for me?
How's the process with this attorney representing me?
Sorry, repeat that.
With this attorney representing?
I will find an attorney. I don't know their name right now. So you still on the protection order case will appear this coming Monday, August 12th, with Mr. Charles Angelico, your attorney in that matter.
My understanding is that a temporary restraining order has already been issued, so I'm somewhat confused about that issue in a divorce petition.
Yeah, I'm having a hard time understanding the question. So what I'm going to do is have you appear Monday for the protection order docket with your attorney, Mr. Angelico. And then I'm going to assign you a different attorney for this family law case. Okay?
One thing is, I don't understand why the protection order is in a divorce when it's already been handled as a petition.
Yeah, so we'll have to address the protection order on Monday, okay? I don't have that case pulled up in front of me. Ms. Powers, is there anything else you need today?
No.
Okay. All right, Mr. Young, you are free to log out. We'll see the parties back September 3rd.
Ms. Gilmore and I have been working on an agreed temporary order. The parties have agreed that the kids are going to Arizona to visit the father. The parents are each going to drive partway and meet each other. The mother is leaving Washington with the kids on August 7th to meet the father, and then we'll pick them up on August 21st. We just want to put that on the record. And then we're going to set this over 1 week for presentation. I believe we've got all agreed temporary orders. We just need time to get the orders sorted out and signed.
I don't, does Miss Gilmore, I don't see
She
her.
indicated that she would not be here today and asked that I put this on the record and set it over a week.
All right, I do see Miss Coy. Does you see any issues with that agreement?
No issues.
Okay, sounds like a good resolution. You wanted this over 1 week for presentation or?
Yeah, 1 week for presentation.
Okay.
And I will add that Mr. Dooley's mother is riding down to Arizona with the kids as well.
Very good. All right, so over the 13th at 1 o'clock for presentation. Thank you.
Thank you.
I did receive a copy. I got a note from Spawaglio. And do we have the state here?
Your Honor. Barb Russell here for the state.
And you had filed a notice of appearance on this one.
I did, Your Honor.
Okay, so
I've also had a chance to review the proposed orders and have no objection to them.
okay.
I got them yesterday, but I had an opportunity, so
Okay,
they
so
look good.
is Ms. Spawaglio, are you present? I'm not.
Yes, I am.
There we go. All right. And I did see the request in time to give them an opportunity to look at it. They're apparently in agreement with the language. So did you have anything else? I thought when I looked through these, they looked accurate.
That was all I was asking for. I also have a question for you, but it's not related to this part.
Okay. Let me go ahead and sign these and I'll take your question. Give me just a second here.
Okay.
And what was your question, ma'am?
So I have not yet filed a proposed parenting plan, and I would like to file that with the court. So the guardian ad litem has the 2 proposed parenting plans to consider before our, I believe it's September 5th is the date he's going to review things. What's the best way can I just file it as a parenting plan without all the attachments to it?
That would be fine. It's mainly we need to know what your position is on all the details within the parenting plan.
Okay.
And just file
I'm planning to file that with.
File the original with the court, a copy to Ms. Powers' office. Ms. Russell, do you wish to have a copy of that?
Yes, Your Honor.
All right, a copy to the state and then also a copy to the guardian ad litem, just so they have that.
I see. Okay.
Okay.
All right. Thank you very much.
You are welcome. Heather, call?
Present. Yes, I'm present, Your Honor. I'm here.
There we go. Okay.
Sorry about that.
All right. So this was on for review, I believe on this big case. So it takes a minute to load. Give me a second here. We're reviewing for, I think it was just a review. We didn't have a specific, but we also did have a presentation. And that, this is an interesting case. I got a proposed order from Ms. Baldwin. I assume that also went out to Ms. Ramos.
It did.
This had to do with the March 26th hearing. And when I got that, I didn't realize that was actually noted on for hearing, because I didn't see the note for hearing, but I did go back and review the audio record. And so I didn't believe that the language in that order synced up with the actual audio record from that hearing.
And so it's been some time, and I'll just ask, so what happened was all 4 children were ordered to have visits with my client. So there's 2 sort of grade school age children as approaching sort of middle school ages, and then there's 2 younger children that are sort of preschool age children. The mother claimed there was an issue at the very first exchange with the I'll call him not the toddler, but the preschool age child. And then the court then said, okay, well, there's some issue, and then stopped visits. My understanding was the court did not intend to say nothing ever, but that the court intended to have these video visits pending some kind of counseling or something getting back together. Obviously, it's been some time and a bunch of things happened intermittently. What was Your Honor's intention? Because it's since you just reviewed the record, what did you intend to happen with the 2 younger children?
Well, what I essentially, there was originally were visits with all the kids, and then what I did in that, and again reviewing the record because it was back in I think it was March we had that hearing. There are a lot of things since. What I indicated was that the 2 younger children may have weekly video sessions with the father. Those were going to be, at least one of those was going to be supervised or at least observed by the guardian ad litem. I didn't require professional supervision, as I recall when I listened to the record. And so the issue would be, as I guess, is if we're going to have a video visit, that needs to be synchronized with Ms. Call so she can observe how that goes and then give the court some feedback as to what should happen going forward.
My understanding, Your Honor, was that the agreement in place at that time was that we would have these video visitations at a professional location, that Ms. Ramos would bring the 2 younger children to that location. I did offer to observe a couple of those visits. I was not willing to say I'd be there for every visit because my understanding was that these were to be supervised due to concerns around how the father communicates with the children. Those visits were never established. I did make multiple attempts to speak with Beth Fellows. That was going to be the agreed upon location. My understanding is that Ms. Ramos did not establish and complete what needed to happen for those visits to occur. I do want to point out, Your Honor, we've not had a review of my guardian ad litem report, in which one of my recommendations is that the children have no contact with Mr. Ramos outside of seriously supervised situations. That has not been addressed in this case yet. I just want to go on record as saying I do think there are some very serious things here that need to be addressed.
So we're here right now reviewing a specific issue about these calls and video visits. And so my clients find that they all be via a professional supervised agency. The reason being that he doesn't want any allegations to surface, and it's just easier to avoid those at this point. Sure. By using Ms. Fellows, so that there just isn't any ability for anyone to make false claims. Your Honor dealt with the DVPO of not only Ms. Ramos in part, but also Ms. Chantel Shirley, where there was a lot of claims, and then some of those really did not suss out, and some of those appeared to be falsifications during that DVPO hearing. And so my client is in a position where he doesn't want to have any risk of false claims. So the professional supervision my client is fine with, because right now it's protective of him. So we would ask that we do that. At this point, I don't have any issue with Ms. Call observing some of them. They should be sort of when she chooses to, requiring her to observe like 50% of them, I think would ultimately be limiting on my client, is that then Ms. Call is oddly, by not being willing to appear, she could limit my client's ability to have a visit. Mm-hmm. So it should be sort of just, if she desires to observe, that's fine that she can. Her observing them should be in a way that in no way disturbs the children. So essentially, if there's like a video feed or something like that, she just should observe in that method, not be in the visit where she's somehow observing it in a way that disturbs the children. I think that creates an unfairness to the children, and it creates sort of an odd situation for the children.
Your Honor, I have no interest in disturbing the visit whatsoever.
Well, all I did was I went back and I listened to the actual record, and the reason I didn't approve this order is it isn't what I said, but if everybody's agreeable to supervise weekly visits by Ms. Fellows, I'm fine with that. And 50-50 split is fine.
And that the 50-50 was part of the order.
That was actually for the guardian costs. That was not for the
Oh,
supervision.
okay.
I didn't address cost of supervision, so.
Okay.
And that's why I said I didn't sync up with the audio record that I listened to. What we should have in a revised order, and I'm fine with the language, it should be may as opposed to shall. I didn't mandate that to happen.
If it's May, then it's not an order. Then mom won't. Then
Well,
we don't have anything actionable.
Okay, so I didn't order shall. And I didn't, because I didn't know what the one of the issues was, is there was an issue with one of the children at the time, not allegedly not wanting to visit. So I was concerned about that. So I have no particular problem with there being a visit that Miss Cowell can observe, and we'll see how that goes. And if I go back and I listen to the actual wording, it was may have up to weekly. It wasn't mandated weekly. So I certainly have no problem with ordering there be at least a visit with Ms. Call present to observe and see how it actually goes. This is a really complicated case. There's a lot of moving parts to it, and the court has a lot of concerns about the whole case, as Ms. Call's obviously expressed concerns. But I think having a visit that the kids can visit with the dad and she can see how that goes and see what the dynamic is would be very helpful. And I'd like to have that happen before we do the jail review, because and so sooner than later. I think we need to get that.
My concern is a single visit allows one party to very much rev up children, and then they have a single visit. Ms. Call observes the single visit, and everything is based off of a single visit, which then encourages parties to behave poorly instead of having a regular, hey, we're going to have once or twice a week, and have a series of visits where then there's children can have a set expectation, and these are children that are of the age where set expectations are appropriate. We're on a review, so the court could say, yeah, I'm going to make that change today. So even if that wasn't your order previously, you can say that's a reasonable change for where we are now. I think if it's a permissive gesture, mother's already indicated she will decline, and that there will be no visits. And we have young children for an extended period of time. All the studies tell us that absent a substantial safety risk, there should be visits. And my client is fully willing to mitigate those through 100% professionally paid supervision.
Well, why don't we do this? Ms. Cole, what's your availability to sit in on visits at all?
Are you
going on vacation anytime soon?
This is what I'm getting to. I'm out of the office starting tomorrow, and then about half of next week. So the week following, the final week of August, I would be available. First week of September, I could do that as well. I'm about to leave town for a few days.
Okay. So why don't we do this? Why don't we put commencing the week of the 19th, sometime to the 19th. I don't know, excuse me, Ms. Fellow's availability. So this will give some time to get that organized. I can put it on for next week for a revised order presentation. So we've actually got the written order in place. And at this point, I'll order, based on Ms. Fellow's and Ms. Call's availability, a weekly visit for, say, the next 4 weeks. I'm not mandating that Ms. Call sit through 4 visits, but if she's available, that would be helpful. And then I'd like to review our guardian ad litem report after she's had an opportunity to do that.
So I just want to clarify. So starting the week of August 19th, and then once a week with Ms. Fellows, and Ms. Call can observe as she desires.
Correct.
Okay.
I will do my level best to be at all 4 of those visits, unless it's just not possible for me to be there. I will do the very best I can to be at all 4 visits.
So maybe kind of let Ms. Fellows know what your availability is, and then she can hopefully kind of schedule accordingly. And then why don't we put this on for review about the 17th of September? That'll give an opportunity to go through some visits. See 1, 2, 3, 4, and then give it. We'll see where we stand at that point. That'd be at 1 o'clock.
And is the court intending for these to be at Ms. Fellow's office with father and children present?
Well, they're video visits, so it would be at her office is where the kids would be. So mom would not be with the kid. Ms. Fellows would be the one, and then Ms. Call can If she wants to be there in person, I'm fine with that. If she wants to visit or observe via video, that's fine, whatever works. But mom would not be with the kids when the visit's happening. Dad would be on video.
Okay, very good. So otherwise, I'll use the same sort of form of the order that I proposed, just with those changes.
Yeah, and I think that the order is probably fine given the modifications we're making today. And then add in the lines about what we just talked about for the reviews and everything else.
I can do that. And then I should be able to get that out today. And then your daughter's just putting it on for next week.
We'll put it on for next week for presentation, and then we'll put it on for the 17th for review of the Guardian Letter report. And Ms. Call, you can just, if you want to just give us whatever your feeling is at that time, verbally, that's fine. If you want to do some sort of a short update, that's fine as well. If you do a written update, if you could make sure that gets to Kelly, my assistant, and I'll have a bench copy to look at prior to court.
Wonderful. Thank you, Your Honor.
Okay, thank you. Present. Fowler and Fowler. Not hearing anybody present, so we will call that at the end of the docket. So this is it's an interesting case. So what's noted on for today is a motion for adequate cause.
And a motion for contempt.
Well, I have a motion, but I don't have any proof of service of that.
Okay, I don't have a problem arguing it at entry, Your Honor. It was mailed out.
I have a proof of service, but it's for notice of appearance and notice of unavailability, a copy of that notice. So I do know there was a motion for contempt filed, but I don't know that it's been personally served.
I haven't received anything.
Your Honor, I believe there was a motion to serve via mailing to the post office box. We don't have an address for Miss Canota.
It's Sonoda, and my email address or my mailing address is the PO box in Longview, which has been included on every single document that I filed.
Correct.
And the last thing I received was your letter stating your dates of availability or that you're not available, which I got on Friday.
It was also publicly published in the newspaper.
Mark, I need you to
Thomas,
read
I need you to
please.
sit tight. You have an attorney, sir.
I'm seeing I see the order to shorten time and the contempt motion to serve via mail.
Mm-hmm.
And it looks like we sent the declaration of service up, but I don't know if it's been filed yet. Again, Your Honor, if you want, we can argue that at entry. They're basically the same issues at this point.
Well, again, I just don't have proof of service that was mailed in a timely fashion. It would have been the concern is, even though there's an order shortening time, that doesn't take into account there's 3 days mailing time or anything else. But
understood.
So look, I did review the motion for adequate cause as well as a response. So, and Ms. Sonoda, that was your motion. Let me hear from you first on that.
On which, Your Honor? I was just asking to change the parenting plan because Mark was aware that I moved with the children to Texas. I told him verbally over the phone. At the time, the whole court system was new to me, so I wasn't sure that I had to actually file papers of a notice to move with the court, but I told him verbally. He was not happy with it, but I told him that we were going to be going before the school year started. He then tried to change the parenting plan behind my back with having me served to my old address months after I had moved. And then I was in Austin, Texas, never hiding my location. My address was on several bills and a lease agreement, and I never received anything. Again, he had my email address, my cell phone number, my Facebook. He could have gotten in contact with me any which way. Never notified me of it. So they're publishing this information in a local newspaper here in Washington, like I'm supposed to see it. That's how they tried to have me served, and then was able to change the whole parenting plan without my knowledge, basically giving him half rights to to the children when he has no emotional connection to them at all. We left him when our oldest daughter was 2.5 years old and the youngest daughter was 7 months. I left him. He's seen them physically in person once, which was in 2019 when I brought them to Chicago to visit my family, and he asked that I bring them by to see him and his then wife, which I did. He showered them with gifts. We came back home, maintained contact via phone and video chat for several months, but then he started to turn violent with them on the phone and getting irritated when they didn't want to chat with him or whatever. Okay. And so I ended contact with him. I told him he couldn't talk to them like that anymore. He couldn't talk to me like that anymore. We were beyond this, because that was why I left him to begin with, because he was violent and aggressive towards me and the children. So for my own mental sanity and that of my children, I ended that. I told him, you want to get a lawyer, go for it. We'll figure it out. Apparently he did, but he waited to do it well after I was gone, and then never told me. I ended contact with him at the end of February of 2021. He never tried to contact his daughters until December of 2021 was the first time that I ever got a message from him saying, hey, Connie, I want to see my daughters. I want to talk to my daughters. That's the first time. And this is supposedly from a man who has an emotional connection to his children and has to see them months. And he tries once to call them. And he's continually tried to reach out and find out where we're at. But in his messages trying to communicate to me, they're always directed towards me and what I'm doing. And I feel like that's a harassment thing. Like, it shouldn't be towards me. It should always be, if you're worried about your children and their well-being, you should be saying, Connie, I want to talk to them. I see on the papers that they sent me, he was messaging me or sending me invitations through a third-party app. I never got those messages. But supposedly he was communicating with me through this, whatever, I don't remember which one it was. I can pull it out, it's in here. But one of the apps says that he's basically sending me invitations back and forth, but they were never coming to me. He was sending welfare checks out to the children like I've ever, put them in harm's way ever in my life. He's suggesting that I was in an abusive relationship and that my husband and I were, like he was abusive in some sort. I don't know where he's got that from. The children have always been well cared for by me. And then I'm actually curious, Your Honor, how he's able to afford a lawyer when he doesn't even pay his child support. How is he affording the luxury of a lawyer?
Okay. Well, I need to focus on the legal issue of adequate cause here at this point. Okay. So that's what we're addressing.
But I mean, I have printouts of conversations that he has messaged me, just talking completely degrading to me. He doesn't care. Like at one point, right before I cut off communication with him, we were discussing him and his wife at the time coming out to visit the girls. It was during COVID, or probably about a year after COVID, or right as it was in its top. And we were talking about it. I was like, yeah, I was trying to help him prepare. I'm like, this is the hotel, you're going to need transportation because we live in a small town, blah, 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 blah. And then we found out my mother-in-law was dying. And I said, hey, hold off on the trip because I think we're going to have to go to Texas to see my mother-in-law because she's literally dying. And then that's when he went out on a tangent about how he could give 0 Fs and this, that, and the other. He says he doesn't swear, but I have proof right here that he's cursing at me and he's degrading me. So that was when I was like, this is enough finally. Because several weeks before that was the last time when he cursed at our daughters on the phone and told them, I put it in all the paperwork, that he was going to F them up if they ever put their hands on me or whatever, because he took something that our, at the time, 5-year-old, I believe, said to heart. She said, oh, Dad, Eleanor gave Mom a black eye. And he literally lost it and started cursing at them, telling him he was going to F them up and he was going to come out here and F them up if they ever put their hands on me again and blah, blah, blah. Taking the word of a 5-year-old at the time, when the reality of it was she accidentally elbowed me in the eye when we were laying down to cuddle for bedtime. And it gave me a little bit of a bruise. the inside joke that me and the girls had that he completely blew out of proportion. The girls were terrified after that and shaking and crying because they didn't know what to do. He has a repeated history of abuse and aggressive behaviors. He's been in and out of jail. He claims that he hasn't, but he has. And I just don't think that he should have time with the girls.
Okay, let me hear from the other side, Ms. Jeffers.
Yes, thank you, Your Honor. Father is requesting that the court deny mother's motion for adequate cause. Procedurally, she doesn't in her petition actually request any modification. In that petition, there is no motion for temporary family law orders. Even so, at this point, there have been no changes in circumstances with regard to father, the children, since the entry of the last order. Realistically, based on when mother said she returned, not even with regard to mother, that would justify a finding of adequate cause. Mother's allegations, which father denies, are almost 10 years old and predate any parenting plan in this case. Mother is certainly not honest with the court when she says father gave himself 50% rights. He gave, in the last parenting plan, he's got some phone calls and an occasional overnight. That is nothing along a 50-50 plan. The reality of the situation is that mother absconded with the children out of state without any notice to father and cut off all communication with father. Father was terrified that the children are not safe. And at this point, we don't have any information as to their safety. Mother's quite right that he has been trying to find the children, not her, but the children, which is contrary to her statement where she says, oh, he knew where we were. I told him. Obviously, he did not. And she admits he's been trying to find where the children are. She also indicates that, you know, he didn't try calling, but then says, no, I cut it off. That is the fact here. We submitted information showing that he has been requesting just his phone calls with the children for a significant amount of time, that mother does not respond. He's filed missing persons reports. It appears the information that he has received, we submitted are from attorneys trying to track down mother and this other person who've basically been committing rent fraud. And at this point, if the children are afraid, it's because of parental alienation, not any behavior by father. We ask that the court deny mother's request for adequate cause. Thank you.
Your Honor.
Yeah, go ahead. Go ahead.
We got evicted out of our house because my husband lost his job. And within 3 months, well, 2.5 months, they put us out on the streets in Texas because my rent was not able to afford that. And I took care of it, and the children were never out on the streets, but that is not rent fraud. I don't know where they're even getting this from. The information that they submitted was simply a text message that he sent to the lawyer that was in charge of the rental agreement with the homeowner, that basically says that this was the amount of money that we owed. And it wasn't even the amount of money that we owed also included court fees. It wasn't months and months worth of rent. It was 2 months worth of back rent, and then the rest was like court fees. So that information is inaccurate. No rental fraud was going on. And if Mark remembers, he got us evicted from our apartment in Nevada 3 weeks after Mary was born. So he can't throw stones at things that happen in life that are out of your control at times. And I told Mark verbally that we were going to be moving to Texas. I didn't give him an exact date because I didn't have an exact date. I just told him it was going to be before the school year started, which everybody knows is either the end of August or the beginning of September. Any parent knows that. So clearly, come November, when he's trying to look for me to serve me these papers, we were gone. We were already gone and settled into our house. The kids were already in school, loving life. He has sent out welfare checks to see the kids, and 2 of the officers did indeed see the children. They know that they're fine and they're well. They know that this is just him trying to have some sort of control. Your Honor, he has never been a father figure to these children. Never. He used to drop them off to me at work when he was supposed to be watching them, and I was trying to make money to support the family. Okay, I fled from this relationship with him because it was abusive and he was neglectful and he was aggressive. All of the above, to make a better life for my children and I allowed him In the meantime, I allowed him to maintain contact with them so that they could know who their father is. And when those contacts became aggressive and manipulative, I stopped them for the better of my children. There's no wrongdoing on my part besides the fact that I'm a mother trying to protect my children so that they don't have to go through the same sort of mental and emotional abuse that I went through with him. Because it's not the first time, and I'm sure it's not the last.
Okay. So this
sorry.
Well, your case is a bit complicated. It's complicated because there's two different parenting plans. The most current one was entered in 2022.
Your Honor,
Ma'am, I need to have you listen. Okay. That is the parenting plan that's currently in effect. And when I read through your motion to change the parenting plan, the only thing that's listed within that happened after 2022, which is where the statute requires I go to look, was I believe it was a receipt of a check or something that was sent to Round Rock, Texas. It was in June of 2022 after the last parenting plan. Mm-hmm. So what I don't have is I don't have a basis legally under the documents that have been filed to give me grounds to reopen the parenting plan as a motion for adequate cause. So the parenting plan of 2022 is the parenting plan that's in effect, and that's the one that needs to be followed at this point. So that's where you're at. I don't know if you have a copy of that. That was
I did get a copy of that from the child support office.
So those are the rules you're working under right now. And so I know I did receive a bench copy of a motion for contempt having to do with not following that parenting plan, which you probably need to take a look at. Sounds like that may be in the mail to you.
That's correct, Your Honor. Can we maybe set that motion, since it was an order to show cause, over 3 weeks? That should be plenty of time for a response. Additionally, if mother starts following the parenting plan with simple phone calls, I'll just let her know at this point. It may be something that we're willing to dismiss. We just want to start moving forward in this case.
I could either set it for the 27th, which would be,
that'd be great
today. So you're going to be getting some stuff in the mail. And frankly, I have some bench copies of that. I'm going to go ahead and just I'm going to give her my bench copies because I've got everything in the court file. So
thank you.
You'll be getting those in the mail. So you have notice of that. We'll come back on the 27th. You need to file a response to that if you want to. If you agree to something else with through Ms. Jeffers' office, that's fine. I would reach out to them if you can work this all out and they dismiss that hearing for the 27th. That's fine. You just move forward into your parenting plan. If not, or you don't wish to follow this, you probably need to get some legal advice. Okay. All right. So if you want to grab a copy of that before you leave, then she's got a copy of the paperwork. Record will reflect that. You should get another copy of that, which may or may not include the cover letter that was sent to the court, but you can have that. So, okay.
Thank you.
Thank you, Your Honor. And would the clerk notes suffice for the adequate cause ruling or a bench order?
Probably clerk's notes are fine on that.
Great. Thank you, Your Honor.
All right. So you want to step up here, maybe grab that copy, and then we'll be back on the 27th there. Good morning or good afternoon. Excuse me.
Good afternoon, Your Honor.
So this has some requests on discovery that need to be addressed.
Yes, Your Honor. The short of it is that I'm simply asking the court to set a CR 26I deadline date for when Mr. Paul's discovery answers are due. You can see the back and forth between counsel's office and my office and the information provided from both of our clients. Discovery's been outstanding since March 22nd of 2024. So we've had over 4 months that have elapsed. We were asked to provide a 60-day extension. We did provide a 60-day extension. And then after that, we were advised that he was taking another 30-day fishing trip. So my client's entitled to move this case forward. We've already heard that the guardian ad litem investigation is going to be completed now by September 3rd. The expectation is that discovery answers and information may be relevant to that guardian ad litem investigation. And at this point, Mr. Prawl has tied my client's hands and my ability to determine if there's relevant information that might be germane to that investigation. I've attempted to secure a deadline date. The closest I could get was 30 days from the end of his next fishing trip. It wasn't until we received Mr. Prawl's reply declaration on July 22nd that it was revealed that he was going to be back here the second week, so next week in August. So at this point, I don't see why August 20th isn't sufficient. The main claim by Mr. Prawl is that, well, I have limited service and I can't produce documents. There's a whole slew of questions that he clearly could have answered that doesn't require documents. And he's made absolutely zero effort at this point. And I've been stonewalled as far as just trying to get a date. So we're asking the court to set that deadline date for August 20th by 4:30 p.m. You can also see the multiple efforts that I've taken in trying to get information from Mr. Prawl. We are asking that the court award my client $1,500 in attorney's fees because I've bent over backwards trying to communicate and get information. And so we believe that that's appropriate. My client has incurred substantial attorney's fees in the multitude of communications that there have been.
All right, thank you, Ms. Jocelyn.
Yes, Your Honor. I was informed by my client just recently. He is expected to return home. He estimates August 16th to 17th. However, he won't get any more than a 2-day advance notice confirming that. It could be earlier, it could be later. Regarding the GAL investigation, nothing they mentioned in their moving papers or reply declaration. The GAL's never reached out to me and said, we have missing information. So the argument they needed for the GAL is irrelevant because the GAL has been provided what she's needed. At no time, Miss Noel is saying, oh, he could have at least answered questions. I could barely get a word in edgewise with Miss McLean. She's never once asked for, hey, partial answers for the interrogatories, not an email, not in her 26I. In fact, I sent her an email asking, is there something important that you need? I can see if my client's family can get it. She never responded to that. I followed up. She never responded to that. Alicia and Miss McLean are quite well aware of my client's inability to do discovery. He is not home working a 9-to-5 job. Regarding his internet, he's in the middle of the ocean on a fishing trip. He has terrible connection with the internet, and depending on certain ways that they face, when the satellite's blocked, it shuts down. It takes him 3 minutes to send a simple WhatsApp message. He cannot download forms and then upload them to me, which are required for me to give them to Ms. McLean. He has extreme limitations uploading and downloading. It's really hit or miss. He cannot make documents, bank statements, credit card statements, anything like that. So there's no way for me to get documents to her. Regarding workforce, he literally has no time. He works 11 p.m. PST to 3:30 p.m. the following day. He then he gets off work, takes a shower, goes to bed an hour and a half later. So I'm not really sure, in this hour and a half when he's getting 3 or 4 hours of sleep, when he's supposed to do something. He can sometimes send me a quick email, but he certainly cannot respond to 32 pages of discovery. Opposing party through counsel keeps saying he has all this time to do things, but has never once provided a declaration. There's no declaration from his boss or anybody on the ship saying that my client's full of baloney and he can do this. Miss Alicia has known, they've been together almost 8 years. She knows what his schedule is. She knows what his trips are like. The email I was referring to earlier was a June 20th email that I sent to Miss McLean talking about his trips and asking if there was something urgent. I could see if a family member could get it. She never responded. I followed up twice. She never to respond. So to me, there's obviously nothing urgent at this time. Also, when they offload, he doesn't have time. I know they mentioned when he comes to offload ships or offload the fish, he can do it then. When the boat gets full, they go in to offload. They have 24 hours. They're working the entire time. They stay on the ship. And then once they've offloaded, they go back out. I know they keep saying he took an extra trip. Well, yes, he lost $50,000 during the protection order. He missed, I believe it was 3 trips. So his intention was always to stay up in the summer to try to recoup some of that. So basically he lost that amount of money. He made a third of the money in May. And really what Alicia's saying is, oh no, you have to come home early and you can't work extra trips, but you still have to pay me the same amount of support. She can't really have her cake and eat it too. It's either does she want him to make the money to pay for their things together and the children, or does she want him to go and work? She wants both, and it's just not possible. He, like I said, he should be home in about 2 weeks. There's really no one else who can get these documents for him. I know this is not ideal. I kept Ms. McLean up to date on this whenever I got the information. In regards to doing this response, you know, they say, oh, she did the response, obviously you could do anything. No, I got about 20 minutes on the phone with my client one time to type up a response. As you can see, we've made extreme efforts to communicate with them, and unfortunately, them bending over backwards is just not the truth. Our request is that Alicia is sanctioned for her and her counsel's bad faith conduct. Ms. McLean is correct that when we first got service discovery, I said he'll be gone for about 60 days. That's all the information that I had at the time. I wasn't lying to her. This is what I had. I can only communicate with Ms. McLean when my client communicates with me. I'm not a magician or a mind reader in that fact. When we set the 26I, you know, generally a custom what I've had is counsel say, hey, we need to set a 26I, when are you available? Ms. McLean just demands, we're doing a 26I on this date. I responded and said, hey, we need to move it. She sends another email, great, it's on this day. I was on the phone talking to a client at this time, trying to get quick responses because I know she gets upset when she's not getting responded to. And eventually I said, look, I'm on the phone, I'll have to let you know later. Then the last email she sent me on that date, I responded to her 18 minutes later, indicating I hadn't talked to Mr. Crawl yet. So to me, setting a 26I when I haven't talked to him, because what we're going to talk about is what has he done? You know, when is he going to get back? When can he do it? I can't for that information without the dates. She never responded to that email. I had to follow up on the 26th, and it wasn't until June 26th when I followed up that I set a date. In fact, I was the one who sent out the email saying, setting the 26I, not her. I sent it out. We had the 26I on July 10th. After I sent a confirming email to her, she never bothered to respond. When we had the 26I, unfortunately, Ms. McLean didn't want to hear anything I had to say. Instead, just decided to blame me for not talking to my client, despite her knowing my inability to communicate with him. Whenever I tried to talk, she talked over me and instead just tried to bully me instead of trying to resolve the situation. I repeated to her, I can do it 30 days after he gets back. I said that to her in an email a month before. I said it to her then. And then she had given me some information such as he had done shipyard work, so off the ocean. First time I had ever heard about that. I said, let me ask my client about that. And if that's correct, then my client and I need to have a stern conversation. She was like, nope, she would not give me a day or two to ask for it. All she wanted to do was set this out. Again, I'm trying to talk with her, let her know it's the same thing. Over talking, bullying, just her wanting to do what she wanted to do and not actually find a solution. And so based on that, Alicia should be sanctioned because there's nothing he can do. Even if the court demands that he produce discovery tomorrow or within a week or the 20, it's not possible because he can't do it while he's on a ship and he's sleeping 3.5 hours a day. I communicate that to them. They've been made aware of that despite knowing this, you know, the inability to do this, inability to work with me, an inability, they wouldn't even let me talk to my client. They went ahead and filed this motion. They're just wanting to drive up fees in this cost. They say I never produced a date for his return, yet she failed to give me any time to find out. In fact, when she starts saying that, oh, he was stateside and could have done the discovery, she found that out on June 26th. She didn't bother to tell me that until July 10th. If she would have told me when she found out on the 26th, that would have given me 2 weeks to talk with him and say, hey, Lucas, what is going on with this? If you were stateside, where are we in discovery? Nope, she didn't. She said, nope, not my clients, I don't have to do it. So knowing he was in the middle of the ocean with terrible internet, had she really wanted discovery, she would have responded to my email asking what's important, or she would have given me some time to talk with him. So at this time, we're asking for the documents to be due 30 days after his return. Right now, it's estimated 16 to 17. I have no problem adjusting that 30-day deadline if he comes home early. I just ask for 30 days and I will notify her as soon as I know, in order denying their fees and in order that she sanction $1,500 for her bad faith conduct. Thank you.
Ms. McLean?
So the court can see sort of what I've been dealing with is the CR26I was set on June 20th and it was set for July 3rd. So that was 10 days for her to reach out to her client to determine what his time frame was going to be. my client outlines, and there was no communication with him or an effort to communicate with him between June 20th and July 3rd. She indicated that she had not talked to her
That's not
client.
evidence. She's assuming I didn't try to have contact. She would know that's not in the decks.
Right. I didn't see that in a declaration, and I don't know the basis of that.
And the 26th wasn't set on the 20th. It was set later.
Go ahead, Ms. McLean.
Thank you. So at this point, we still, now we're told he's going to be back August 16th or 17th, and she wants 30 days from then. I'm entitled to a deadline date. That's what CR 26I is required or allows for, so that if he doesn't comply, I can move forward. It's interesting that he's able to receive, review, and electronically sign a declaration with multiple pages of attachments in a week, but he can't provide even an email or in a phone call answer questions relative to discovery. It's not my responsibility to tell counsel how to do her job or to tell her client that he needs to provide partial answers or information that's available to him, because I don't know any of that. That's what I'm trying to get. There were a multitude of parenting plan questions that were included in my client's discovery request, and I believe that some of those may be relevant to the parenting plan issues that the guardian ad litem is investigating. But again, I'm hamstrung because I have nothing for the last 4 months and 2 weeks since discovery was served. So we're asking the court to grant the motion, order that discovery is due August 20th by 4:30 p.m. And if they don't comply, then that will allow me under the civil rules to pursue a motion to compel. We are asking the court to grant my client's request for attorney's fees, deny their request for sanctions. I've done everything possible to try and get a date certain when discovery answers would be due.
All right, thank you. So court is aware of the circumstances of the parties that have been dealing with this case off and on between this case and the companion protection order matter. So I'm familiar with the particulars of the circumstances. I'm going to set a due date of 9/3 or 30. So not 30 days, but it's sufficient time. I'm going to reserve on fees at this point. I'm not going to grant any sanctions. It'll be the order today.
You do have a proposed order in front of you. Are you willing to just interlineate, or you should have a proposed order?
I do have that order, and I'm making those changes to that order.
Okay, great.
And
you also add in there then that you've denied respondents' request for sanctions.
Correct.
And just because my phone is a little hard, did you say 9/3 on the discovery response?
Correct. 9/3 of 2024 by 4:30.
Okay. Reasonable.
And I'm adding in that all other language that'll be available in Odyssey in a couple of days.
Thank you. I'll provide that to counsel. Thank you.
Welcome.
Yes, I am, Your Honor. I'm having some internet problems though, so if I can leave off my camera.
All right. So on the Fowler and Fowler matter, is Ryan Fowler present?
And I don't imagine he will be. A lot of that is just bookkeeping. My client did change lawyers. And so because of that, we're trying to get the trust at the other firm to be dispersed to us, but they do need to be paid.
Right. I do have a proposed order and I will sign that.
Thank you, Your Honor.
All right. And with that order.
All right. Thank you, Your Honor.
Welcome. Oops. Almost to my, hey, clerk's arms aren't long enough. All right, so that brings us to the Jones and Jones matter. A little confused on this case. We have Ms. Holder?
Yes, Your Honor.
I believe this is your motion?
That is correct, Your Honor. There are some procedural defects that are not fatal. I believe that is addressed in my client's reply declaration. The intent of this was to modify the parenting plan, but but it appears that a petition as opposed to a motion was filed, but the effect would be the same if Your Honor decides to hear the case and to modify. Currently, I do agree that there is a procedural error. However, Mother does argue the case should be dismissed while simultaneously asking the court to modify the parenting plan without filing a motion to modify. And it would be in the best interest of the children to hear this case today as both sides are seeking a modification.
Ms. McLean, you want to respond to that before I get into the meat of this?
Sure. As it relates to the procedures, we are asking the court to dismiss the petition. There has been no adequate cause motion submitted to the court with the petition for the court to do a preliminary look-see under RCW 2609-270 and issue an order to show cause. So the petition itself is procedurally ineffective due to there not being an order to show cause issued by this court and no motion for adequate cause. Technically, the statute, when we're under a temporary parenting plan, only requires a motion for purposes of modifying that rather than a petition. And even on that issue, unfortunately, there is a procedural defect because there is no motion before the court. What you have before you that's identified as a motion to resume residential time is actually a proposed order. It's not an actual motion asking for specific relief. It's an order. And so it's sort of interesting because if you look at the footer, it identifies as the name of it is a notice of hearing. I didn't even look to see what Form 185 was, but I'm assuming that that's an order because that's what the language is an order that's signed by a judge. So our position would be is that there technically is no motion before the court and that the court should deny any request at this time. We would ask that the court also consider an award of attorney's fees to my client under RCW 2609-260 subparent 13 in the amount of $1,800 because we have had to file a response to this petition despite the procedural abnormalities. And we have filed responses to the documentation, even though there's these procedural defects.
And Your Honor, if I may respond to that.
Sure, go ahead.
This is a case where father hasn't seen his children since November of 2023. This is a temporary parenting plan, and adequate cause motions are generally used for modifying final parenting plans. Because this is a temporary order, no adequate cause motion is necessary. There is a motion in front of the court to resume visits, and while it might appear as an order, the title and the caption is a motion to resume visits. And if the court would be willing to entertain that motion, we just need to get something going so this father can see his children. For whatever reason, under Section 4 of the parenting plan, where the limitations are in place, it says visitations cannot resume until further order of the court. We have not been able to get visitations going for whatever reason, and that is why we are here today. Visitations have been paused. We have been stonewalled to get visitations going, and at this point, something needs to happen for this father to see his children. He hasn't seen them in 9 months.
Okay. I feel at least somewhat vindicated that I was confused procedurally. So you've got a temporary parenting plan. This is the one, it looks like it's one under 921-23, which we'll talk about that in a minute. So procedurally, I did some research on this. It seems to me that this is essentially looking at Marriage of Watson, which is 132 Washup 222. That would indicate that even a temporary plan needs some sort of adequate cause type finding, whether it's done in the formal process or done by the show cause method. That case would indicate to me that even though the statute isn't as clear as it could be, it still requires some showing that there's been a change of circumstances to justify modification of a parenting plan, which is, for lack of a better term, adequate cause. again, the process isn't as clear under that statute for a temporary plan, but it does seem that that still governs. So the petition itself, I mean, we've already got a case going, so it's like a case within a case, which doesn't need to happen. And I don't know if there even needs to be a modification of the parenting plan, because when I read the parenting plan, so there's not been a showing of adequate cause. I'm not going to make a change in the current parenting plan. So the current parenting plan from September is the parenting plan in place. That plan has challenges because it's inconsistent in its language. It requires, which I don't know why this is in there, but it requires that if there's a positive UA, that terminates visitation pending further court order, yet the parenting plan provides for visitation prior to there being a clean UA. So I don't understand. It's completely inconsistent to have that language there. So it seems to me where you're at right now is he has supervised visits pending further order of court under your current plan. So I mean, that's kind of where you're at.
And Your Honor, currently with everything that we have submitted to the court, which is a clean UA, a clean hair follicle test, as well as completion of his treatment, he should be in unsupervised visits at this time, according to Section 8.2 of the parenting plan. Section 8.1 provides for supervised visits as long as he is still testing positive.
Well, and that's the concern, is that first off, in regards to a treatment plan, we had received an initial analysis of his substance use and whatnot from Safe Haven. That evaluation said that it was for 4 weeks, that they were going to redetermine after that for relapse provisions and the like. We never got a supplemental treatment plan. So at this point, we have no idea what treatment plan they were operating under for the last almost year. The second issue is that during the course of treatment, he tested positive for alcohol use in November of 2023. He provided a dilute sample on April 5th of 2024. There's no indication that the treatment agency was aware of his dilute sample. And the clear language of the parenting plan provides that a dilute sample also is considered positive for purposes
Objection,
of the
Your Honor, that's not what the parenting plan says.
Well, the reality is at this point, he's under supervised visits under the parenting plan. And I'm understanding that's not happening, but that's where he should be based on the parenting plan, the clear terms of the parenting plan. The clearest terms. It's not a very clear parenting plan, but that's what it seems to say.
Okay. Then
and if there's a question about whether or not he should go to unsupervised, that would be subject to a motion that I don't think has been filed. So,
And Your Honor, if I may, what motion would that be?
I'm sorry?
If we were to file to move into unsupervised visits, what motion before the court would it entertain?
Counsel, I'm not in a position to give attorneys advice on how to practice law, but I think that if he's got a positive test, he's under the provisions that indicate he's under supervised visits. If you want to file some sort of motion that puts that issue back in front of the court, I'm happy to hear it.
Thank you, Your
Honor. Fees for the having to respond to the petition and the procedural difficulties with this case, we've asked for $1,800 in fees because of the deficiencies. My client has incurred a lot of attorney's fees in having to respond to this, and we think that that's appropriate. I did provide to the court a proposed order.
Counsel, you want to address that?
Yes, Your Honor. If anything, I believe fees should be awarded to my client for having to go through all of these hoops in order to restart his visitation when it's very clear that it should have been started months ago when whether or not he submitted a clean UA, even with a positive UA, he should have still been in supervised visits since at least November.
Well, Your Honor, at this juncture, if you take a look at the UAs that were submitted by them, there is not one scintilla of evidence that any of those are observed. And my guess would be that they are not observed UAs that they've produced because Deborah Johnson is the one who collected them. And I think that there are typically strict policies that you have to have a male present for observation of a collection from a male. So there are.
I'm not making any kind of ruling as to whether they're good UAs or bad UAs. I'm just looking at paragraph 8 of the parenting plan. It says until he's got a clean UA, he's got supervised visits. So the fact that we're here at all is concerning. He should be under supervised visits and probably should have been all along. I mean, the parenting plan as it's written is not consistent. It's got two different outcomes that don't logically fit well together. So I'm not going to work these either way.
So is the court making changes to the order that I provided?
I'm not making any order other than I'm denying the motion for, I guess this would be an adequate cause essentially, but it's not an adequate cause. I have a motion to resume parenting, which there's no reason for me to enter that because it's already under the current parenting plan. I really don't have a pending motion that's in front of me to deny or not deny.
So as far as at least my client's response to what we have here, is the court dismissing the petition?
I can sign an order dismissing the petition. I don't know that it's even effective as there's summons in the case, but I mean, there's already a case that's within the same case. So there's not a new case. That's why I said I was very confused when I was trying to read through this, figuring out what we were doing.
So just for clarity, so that we don't have to have this educational discussion in the future, I would ask that there be an order entered to dismiss the petition.
I will be happy to do a bench order dismissing the petition.
All right, thank you.
And I believe that's all the matters I have pending on this case and on the docket.
Thank you.
Would like to ask, Your Honor, that one other bit be put into that order, just so it is sure that it's done under the parenting plan. My client is supposed to, according to the court, be in supervised visits Tuesdays and Thursdays from 5:45 until 7:45. That would be today. Without signing off on an order to resume visitation, is there anything that can be an enforcement mechanism to make sure those visits do in fact happen, besides waiting to file a motion for contempt and coming back in a few weeks?
I'm not going to sign an order that restates the obvious. So I assume that if that's what it says and it's supposed to happen today, then that would happen today. -08.
Thank you, Your Honor.
Ms. Winkles is present. It's Mr. Goodday. I do not see Mr. Goodday.
And I've received nothing back in terms of interrogatories or discovery responses. And that might be why he's not here. I'm assuming he has tried to get those.
Let's call that again.
Okay.
Got a real short docket. He may be still logging in here on that matter.
Okay.
I'm here.
All right. Good morning. Ms. Turnbull, I see you are involved in this matter.
Good morning. Yes, I'm sorry. I think I was logging in as you were calling it.
Yeah, this is the Angel Alejo matter.
Yes.
I'm not exactly sure why this is on today. That looks like there's a temporary order that goes through the 16th of September. So I was unclear. We don't have a full guardianship filed on this one, so I'm not sure where the parties are at on it.
We're working on getting father served. We've partially located him. He's on the sex offender registry in Oregon, but the address that he has listed is I don't know if incorrect is the right way or to say it. I don't think it's accurate. But so the police are looking for him. So we're working on that. And I believe mother's been served. Is that right, April?
I've paid the sheriff a few times, so I'm hoping this time they're able to serve her.
Okay. But I think other than that, she's got everything else in. And I think April was under the understanding she filed the guardianship papers. Is that right? Or you hadn't yet? You thought you had?
Yes.
I'm not sure when that was done because the only thing I have right now is the emergency petition.
I did they told me the fastest would be the emergency and to do the short term for now. and then I'm going to go back and do the long term, but I did submit the short term.
Right, the short term is the one we're dealing with, and it's valid through the 16th of September. So I think probably at this juncture, we may just want to set a review about the 10th of September, check status and everything, and see if we get their full one filed. That's as far as I can go on this order. It can be extended out 60 days at that time, assuming we're still in process. And you may want to talk with Mr. Turnbull about the service questions on the father. But at this juncture, I don't think there's anything else to do today other than we can review it on the 10th of September and check I think it was the 10th, excuse me. That's not right. Yeah, September 10th at 10:30.
Okay, that works for me.
All the request was on for discovery reviews today. All right, you're welcome.
Yes, Your Honor, last time we submitted a response, and I think Ms. Winkle said if, we didn't respond more, then there may be issues with what my client would be allowed to testify to.
Yes, they essentially responded with not applicable or something to that nature to almost every question. So in that case, Your Honor, I would ask that their testimony be excluded on any question they didn't answer in full, which is probably about 90% of them.
Well, they would be limited to whatever discovery responses that they responded with. So that wouldn't be, I don't know what was answered, so I'm not going to just make a blanket exclusion of testimony.
And in that case, Your Honor, I can actually submit their responses and also the questions that we want excluded. If we set this over 2 weeks, I'd have time to do that. That might be easier. And it might also give them time to answer, because I still don't mind I'd rather have the information than have the testimony excluded.
All right, do you want to set it over to the 20th for review? And then Mr. Goodday, if you want to provide additional answers, that we can consider that on the 20th?
Yes, Your Honor.
All right, so 10:30, 20th of August.
All right, thank you, Your Honor.
You're welcome.
Thank you.
Mr. Reisenberg, I see you are present. Good morning.
Morning.
And who else do I have here? Do I have Anna or Anthony Wessel, or where are we at on this case?
So this is just our initial hearing. Brad Hurst, one of the petitioners, is here. He's unmuted, but his camera is not on yet. And so we're just getting the ball rolling on this one. I see that the court has already issued an order for DCYF to release records. I mentioned they have not been received yet. I also still have a couple affidavits of service and consent by the father to file today.
Okay. So at this juncture, I guess, where do you want to proceed today? I don't have those in front of me. So do you want to set this out a week for a review of those, or how do you want to handle this?
I would ask that we send it out maybe 3 weeks just to give Linda Hurst, the other petitioner, an opportunity to request time off work. She would like to be here for it. And I imagine it'll probably take that time to get the DCYF records anyway.
Okay. So you want to go to the 20th or the 27th?
Let's do 27th.
Okay.
So there's not a strong deadline. Our real deadline here is the petitioners do have a childcare POA in place, and it doesn't expire until October.
Perfect. All right, we'll put it on for 10:30 on the 27th and proceed forward at that time.
All right. Thank you, Your Honor.
You're very welcome. And that is the extent of our docket this morning, so we will adjourn until next week.